5 seconds to go. Start. For the purpose of the claims in regard to the matters which are not specifically dealt with in the BDA Act, reference to the LA Act in terms of section 36 has been made. The intention of the legislature is to take recourse for the provisions of the LA Act to a limited extent and subject to the supremacy of the provisions of the BDA Act. This is evident from the expression so far as they are applicable employed in subsection 1 of section 36. In Offshore Holdings Private Limited Supra, a constitution bench of this court, after considering the scheme of the BDA Act and having regard to the language employed in section 36, held that it is a legislation by incorporation. Incorporation of an earlier act into the later act is a legislative device for the sake of convenience in order to avoid verbatim reproduction of the provisions of the earlier act into the later act. Once the incorporation is made, the provisions of incorporated statute become an integral part of the statute in which it is transferred, and thereafter there is no need to refer to the statute from which incorporation is made, and any subsequent amendment made in it has no effect on the incorporating statute. In Offshore Holdings Private Limited Supra, it was held as under. All these provisions show that the BDA Act has provided for a complete adjudicatory process for determination of rights and claims. Only in regard to the matters which are not specifically dealt with in the BDA Act, reference to the Land Acquisition Act in terms of section 36 has been made, for example, acquisition of land and payment of compensation. This also is a pointer to the BDA Act being a self-contained act. Applying the above principle to the facts of the case in hand, it will be clear that the provisions relating to acquisition, like passing of an award, payment of compensation, and the legal remedies available under the Central Act, would have to be applied to the acquisitions under the State Act, but the bar contained in sections 6 and 11A of the Central Act cannot be made an integral part of the State Act, as the State Act itself has provided specific time frames under its various provisions as well as consequences of default thereto. The scheme thus does not admit such incorporation. The sequitur to the above principle is that the BDA Act has already been held to be a valid law by this court, not repugnant to the Land Acquisition Act, as they operate in their respective fields without any conflict. For the reasons afore referred, as well as the detailed reasons given by us in Girnar Traders, which reasoning would form part of this judgment, we have no hesitation in concluding that the BDA Act is a self-contained code. The language of section 36 of the BDA Act clearly mandates legislation by incorporation, and as per the scheme of the two acts, effective and complete implementation of the state law without any conflict is possible. The object of the state law being planned development, acquisition is merely incidental thereto, and therefore such an approach does not offend any of the known principles of statutory interpretation. Stop.